What truth do you think the SEC is hiding? How long will this information be hidden from us? We will answer these questions in today's video. No one anticipated that the creation of the XRP coin in 2012 would set off the SEC UVs. Ripple litigation, one of the most famous legal fights in blockchain history. Ripple was one of the biggest digital assets in the crypto industry before Ethereum was even a glimmer in Vital XI. For a long time, crypto news was dominated by the SEC's case against Ripple. Crypto aficionados have gotten desensitized to the fight over time. The fate of XRP, Bitcoin, Ethereum, and the whole cryptocurrency industry hangs in the balance of the cease lawsuit. Ripple blockchain is a distributed digital payment system similar to Bitcoin. When it was first introduced in 2012, Ripple's primary goal was to facilitate the rapid and cheap international transfer of multiple fiat currencies. The SEC has filed a complaint against Ripple Labs and its CEO Brad Garlinghouse and co-founder Chris Larsen. This is the official case that the XRP lawsuit refers to. In New York, the case is being presided over by Judge Annalisa Torres of the District Court. So what exactly are the SEC and its unmovable chairman Gary Gensler charging Ripple with? Every day, dozens of individuals buy, sell, and trade cryptocurrency tokens on secondary markets. Why should XRP be singled out for such heavy SEC regulation? In 2020, the SEC filed charges against Ripple Labs, alleging that the company had raised over $1 billion via the sale of XRP coins, making it the largest regulatory case in the cryptocurrency sector to date. If you've been involved with cryptocurrencies for more than a week, you're undoubtedly aware that ecos like this are widespread. The SEC has a major problem with the sale of XRP coins by Ripple Labs and its executives because, as they see it, these sales constituted unregistered securities offers. According to the Securities and Exchange Commission, SEC, XRP is not a currency but a security, instead, making it subject to applicable securities regulations. According to the SEC, Ripple's CEO and co-founder were also less than forthright over the course of the transaction. They claim that Garlinghouse and Larsen broke federal securities laws by making false and misleading claims regarding the XRP coin and by failing to formally register the transaction. In conclusion, Gensler LLC Company assert that Ripple Labs had knowledge that XRP should be classified as a security but deliberately withheld that information from its investors. However, proponents of Ripple maintain that XRP is a money and not a security. Thus, it is exempt from regulation under federal securities laws. The XRP coin is not a security under Ripple Labs' definition. While XRP is a currency and not a security, Ripple denies the allegations made against them. Ripple claims that the SEC's incorrect classification of the XRP coin and the XRP sale as an unregistered security sale are at the heart of the whole legal dispute. Ripple, to rub salt in the wound, asserts that the SEC's contradictory approaches to cryptocurrency regulation stifle a dynamic and forward-thinking sector. Ripple's CLO, Stuart Alderodi, has urged that Gary Gensler should step out from any further categorization of cryptocurrency decision-making. According to the attorney, Gensler's future conclusions are suspect because of a recent interview in which the head of the U.S. Securities and Exchange Commission said that all cryptocurrencies except Bitcoin were securities. For the second time, Chair Gensler has declared that all cryptocurrencies are unregistered securities, with Bitcoin being the only exception. As he has already made up his mind on the result, Stewart tweeted he must now disqualify himself from voting on any enforcement case involving that subject. Gensler implied that all other cryptocurrencies were securities in a wide-ranging interview with New York Magazine published on February 23. He argued that this was the case because there's a group in the middle and the public is anticipating profits based on that group, which was not the case with Bitcoin. However, his comments were misunderstood to imply that all crypto assets other than Bitcoin were within the SEC's purview, and he received severe condemnation from the crypto community as a result. Attorney and Blockchain Association policy lead Jake Chervinsky tweeted that Gensler may have prejudged that every digital asset apart from Bitcoin is a security, and that unless the SEC establishes its case in court, it lacks the jurisdiction to regulate other cryptocurrencies. In addition, the attorney stressed that Gensler's opinion is not the law, despite the commissioner's claims of supreme control over the Bitcoin market. XRP supporters are still waiting for the court to rule on whether or not the cryptocurrency should be classified as a security, despite the fact that the years-long litigation against Ripple is drawn to a conclusion. It's worth noting that although the case's ultimate conclusion is still up for debate, many other judicial decisions involving essentially identical fact patterns have provided some indication of what could happen here. As an example, in March 2021, the SEC filed a lawsuit against Elbri, a blockchain-based sharing platform, for selling its LBC tokens without first registering them with the SEC. A judge on the Court of Appeals recently decided that LBC tokens are not securities until they are sold in the main sale. If Ripple can persuade the court that, like Elbri, it never officially had an initial coin offering, the outcome may be favorable. If Ripple prevails, XRP may be relisted on major cryptocurrency trading platforms like Coinbase and Binance, which would be a huge boon to the coin's value. Ripple's general counsel, Stuart Alderoty, has said publicly that the blockchain firm would immediately appeal its lawsuit against the SEC in the event that Judge Annalisa Torres rules in favor of the regulator in her summary judgment decision. Yesterday, in an interview with Blockworks, Alderoty revealed this information to us. According to Ripple's general counsel, there are 3 different scenarios that might occur in the ongoing legal battle with the SEC. The outspoken general counsel claims that it is possible for Judge Torres to rule in favor of Ripple in the summary judgment proceeding. Second, he said that the judge has the ability to determine that there are contested facts, which will be addressed over the course of the trial. Alderoty said in his third point that Judge Torres could decide to rule in favor of the Securities and Exchange Commission if he decides to give summary judgment. In the event that this transpires, the general counsel for Ripple has said that the Silicon Valley technology business would not accept a victory for the SEC and will instead immediately challenge the matter before the U.S. Courts of Appeals. In addition, according to Alderoty, Ripple is planning to take the issue all the way up to the Supreme Court if the Court of Appeals does not rule in favor of the blockchain business. The members of the XRP community gained confidence as a result of his assurance that Ripple will prevail in the lawsuit before the Supreme Court. Alderoty predicts that the Supreme Court will find in favor of Ripple because to the safeguard it provides against the establishment of an administrative state. According to Alderoty, I would be very convinced that this is a victory at the Supreme Court. Not so much because of crypto problems, but more because of the guarding against developing an administrative state. Citation needed it. In addition, the general counsel for Ripple has indicated that the much-anticipated summary judgment may take place before the month is out. Because of the lack of clarity over how regulations will be implemented, Alderoty recommends that new cryptocurrency ventures do not start in the United States. According to Alderoty, these new cryptocurrency initiatives have to be launched in a country that has developed laws that are applicable to the business. New crypto firms should go to a country where the regulations are clear, not light. Touch, but explicit, he added. New crypto businesses should move to a jurisdiction where the rules are clear. Because of this animosity, a number of crypto firms are mulling about the possibility of leaving the United States. According to a story from the previous month, Ripple CTO David Schwartz dropped a hint that the business would leave the U.S. if it is put in a position where it has no other option. In a recent interview with Bloomberg, Ripple's chief executive officer Brad Garlinghouse gave his support to Schwartz's statement. According to Garlinghouse, cryptocurrency firms are already moving out of the United States because of the country's failure to get its act together. He continued by saying that us crypto enterprises that operate abroad are not appropriate for the creativity of the nation.